Yes, Mr. Chairman.
May it please, my Lord. Section 145 says that where payment falls within the terms of that section, it is invalid. That's the word it uses. So the first question, logically, is what is the nature of the liquidator's claim following a declaration under Section 145 that the payment is invalid? Now, the position at common law was clear, and in the supplemental authorities bundle at tab 1, you'll find Marks and Feldman and the position here set out at page 7 of the Supplemental Authorities Bundle, 281 of the report. And just under the first indent here, the transaction was voidable at the suit of the assignee from the time the property of the bankrupt became vested in the assignee. He might have avoided it and maintained an action of trover if the goods had remained in the possession of the transferee. And after the latter had converted the goods into money, the transaction still remains unlawful as against the assignee, voidable by him, voidable as against him. And the only difference is that whereas the remedy would be an action in trover after a demand, that is, after an avoidance by way of demand, while the goods were in specie and in the hands of the transferee, when the goods have been converted into money, the assignee becomes entitled to maintain an action for money hadn't received. After a demand for the money so hadn't received, transaction remaining in effect the same and the remedy only differing. And then there is some Australian authority, tab 2, case of Kratzmann. This is the High Court of Australia's decision, and it refers to an earlier case. If one picks it up at page 14 of the Supplemental Authorities Bundle, 298 of the report, the first full paragraph, Section 95 of the Bankruptcy Act, of course, dealt not only with payment of money, conveyances, transfers of property, and so on, as of course does Section 145. The consequences of avoiding transactions or dealings of such an assorted character may well differ from case to case, but there can be no doubt that the court may, in an appropriate case, make not only a declaration, but also afford consequential relief by an appropriate order, may declare a conveyance of land void and direct the delivery up of the relevant instrument or reconveyance of the land, and so, until you get down to about 10 lines from the bottom, where what is the position where A has made a payment in discharge of his indebtedness to B? Both have been adjudged bankrupt before A's trustee has obtained a declaration the payment is void. In such a case, the declaration in no way affects title to specific and identifiable property. It merely means that the money was not paid in discharge of A's indebtedness to B, and if it is to be repaid, it must be repaid out of the estate of B. Re Ward, Thomas and Abbott, Justice Payne expressed the view that in the case of a payment avoided as a preference, the right of the bankrupt's trustee was equivalent to the right to maintain an action for money hadn't received. Much the same was said as long ago as Marks and Feldman. Again, in Kratzmann, number 3, the Chief Justice said, whatever rights the liquidator has in this respect must be derived from the general law, which becomes applicable upon the avoidance of the company's transaction. Of course, the liquidator may assert such rights in proceedings taken in liquidation before the Supreme Court because of that court's general jurisdiction. But the rights which are being asserted are rights other than the right to a declaration of the avoidance of the debtor's transaction must, as I have said, be found in the general law. So since the court has authority to make orders affording relief consequential upon the making of such a declaration, find it unnecessary to equate the right of a trustee to recover the equivalent of a payment declared to be void within the strict terminology of the common law. Sufficient to say in such a case the declaration doesn't affect the title, and he goes on to say, in other words, you're just an unsecured creditor. That case was considered in the Kratzmann cases in the Supreme Court of New South Wales at tab 3 in Starr and O'Brien. And the relevant passage is at page 29. So there's a short passage dealing with section 94 at the bottom of the page, 442 of the authority. It was undisputed that the right of a liquidator to recover a payment avoided as a preference arose as a matter of general law. And then you'll see the references to Kratzmann number 1 and so on. The right of recovery is pursued through an action previously held to be based on a claim for money hadn't received. That's Marks and Feldman, Kratzmann number 2. Now correctly to be regarded as based on a claim for restitution or unjust enrichment grounded in mistake or illegality. That's putting a more modern gloss on it. If we then go to volume 8 of the authorities bundle and put the supplemental bundle aside for the moment, at tab 30, volume 8, it's the first tab in the bundle at page 2532, the decision of the Court of Appeal, the Lady Justice Gloucester, Lord Justice Patton, Lord Justice David Richards. And you'll see at 2524 a brief statement of what the action relates to. It's an application by trustees in bankruptcy, pursuant to section 284, in relation to transfers of minority shareholdings in 3 companies made by the bankrupt to the first appellant and later transfers by the first appellant. And they took place in the context that we come to 2532, the relevant discussion. Section 234, you'll see at the bottom of the page in the footnote, the text is set out there. Where a person is adjudged bankrupt, any disposition of property made by that person in the period to which the section applies is void, except to the extent it is or was made with the consent of the court or subsequently ratified by the court. And it applies to the period beginning with the day of presentation of the petition, ending with the vesting of the bankrupt's estate. It's equivalent to the 127 UK Insolvency Act, 227 of the Companies Act, the 48. And you'll see at paragraph 29 the discussion. In the respondent's notice, the respondent submitted the judge ought to have concluded section 284 provides a freestanding right to recover the compensation ordered. I disagree. In my judgment, section 284 only operates to avoid relevant dispositions. The section is silent as to the remedy available to the bankruptcy estate when a disposition has been avoided, and the appropriate remedy is accordingly governed by the general law. Point decided by this court in Holocaust contracts. Lord Justice Mummery referred to Mr. Justice Oliver, pointing out in Leslie Engineers, the invalidating provisions do not spell out the appropriate remedy of the company when the disposition is avoided. The right of recovery of the company's property, which has been disposed of, is determined by the general law. It's common ground in these proceedings. The right of recovery, whether invoked against the payees or against the bank, is restitutionary. Now, we say no relevant distinction is to be found between a payment being found to be void under section 284, section 227 of the 1948 Act, or a payment which the court declares to be invalid under section 145 of the Cayman Companies Law. I'll come on to an English authority which suggests there might be a difference in principle, but in either case, the transaction is void. The consequence, you look at the statute, and 284 says that that transaction is void unless the court validates it. Section 145 says that the transaction is invalid. It's the consequence of those events having taken place. But the statute in each case is silent as to the consequences, and that is left to the common law. Contrast that with the UK Insolvency Act 1986, which sets out very detailed provisions over a number of sections as to the power, a statutory power of the court to require certain persons to make certain payments, subject to certain conditions against some of those persons. And there is a whole statutory regime. And I just ask you not to go to that, but to note that there is that statutory regime, because in some of the academic commentaries, which my learned friend may take you to, you'll see that those commentaries are, so far as they relate to the position under the Insolvency Act, do rely upon the fact that there is a statutory repayment regime. Clearly, we don't have that here. So, to conclude, the nature of the liquidator's claim is one in money hadn't received. Perhaps, in more modern terms, unjust enrichment. So the second question is, was SEB enriched? And there is clear authority that it was not. If we go back, please, to the supplemental bundle, at tab 4, Portman Building Society case, decision of Lord Justice Millett, I'd ask you to look at, his judgment, so decision of the Court of Appeal, judgment of Lord Justice Millett at page 37 of the bundle. And a passage on page 668 of the judgment at D to F, the formulation explains why any claim to restitution raises the questions: has the defendant been enriched? If so, is his enrichment unjust? Is his enrichment at the expense of the plaintiff? There are several factors which make it unjust for a defendant to retain the benefit. Mistake is one of them, but a person cannot be justly enriched if he has not been enriched. A person cannot be justly enriched if he has not been enriched at all. That's why it's necessary to ask all three questions, and why the fact that a payment may have been made by mistake is not by itself sufficient to justify a restitutionary remedy. In the present case, the firm was not enriched by the receipt of the money. The money was trust money, which belonged in equity to the society. It was probably paid by the firm into its client account. The firm never made any claim to the money. It acknowledged that it was the society's money, held to the order of the society, and it was applied in accordance with the society's instructions in exchange for a mortgage in favour of the society. The firm did not receive the money for its own use and benefit, but to the society's use. Given that the money was held to the order of the society, the only question is whether the firm obtained a good discharge. Here, SEB held the shares as custodian and nominee. When the redemption proceeds were paid to SEB, they belonged in equity to Catella or to HQ Solid, as the case may be. SEB properly paid the proceeds into accounts in the fund's name, where they remained trust property and were held to the order of the funds and were applied in accordance with the fund's instructions. So even if SEB held the funds as banker rather than nominee, it was still not enriched, because on crediting the bank accounts, it had a corresponding obligation to the account holder. There's a passage in the Company Commercial André and Artibel case at tab 5, decision of the Outer House, and that's at page 49. It's the passage I'll ask you to look at. The key question here, incidentally, just by way of background, was that the issue was whether an advance rate payment had been received by the bank on its own account as absolute assignee, or whether it was only received on its client's account by way of security. And it was held it was by way of security, so it wasn't an absolute receipt by the bank. And you'll see that at the top of paragraph 15. At B, in my opinion, the second defendants did not receive the advance rate for their own account and were not enriched to any extent by the receipt. The pursuer's case of unjust enrichments perilled on the assertion that the advance rate was received by the second defendants for themselves as absolute assignees, not merely as the first defendant's bankers for crediting to the first defendant's accounts. That was then considered in the rest of 15, but at 16, There is no doubt a sense in which money paid to a bank to the credit of the account of one of its customers becomes, on receipt, the bank's money, simply consumed by the banker. But in that simple situation, the bank is not thereby enriched, because it grants an immediate obligation of corresponding amount to its customer. Receipt by the bank in that way would not, in my opinion, afford the necessary foundation for an argument. In the event of the money becoming repayable by the customer to the bank has been unjustly enriched. I do not understand senior counsel for the pursuers to argue otherwise. And then that was referred to in the case of Jeremy Stone Consultants, which you'll find at the supplemental bundle tab 7, and at page 159, paragraphs 240 to 246. My lords, I won't read it all through, but I would ask you to look at this carefully. It was money. There was a claim for unjust enrichment of NatWest by its receipts of monies paid by the claimants into SEWL's accounts. SEWL was the fraudster in that case, with NatWest on the basis of mistake. They did pay the money. 241, no claim in unjust enrichment. It wasn't enriched by the payments, or if it was, it has a good defence. Issue of enrichment, and you'll see at 243, NatWest wasn't enriched because it just reflected the increase in bank account and it had to a corresponding obligation. So it wasn't enriched, and Andre and Artibel is referred to there. Proper unjustment enrichment claims against SEWL. And my lords, it's worth noting, of course, that if the transaction is held invalid, it's not that the liquidators are without a remedy. They may pursue a remedy against the wrong person. And then 244, even if I'm wrong about that, NatWest was enriched in a relevant sense, would have a good defence to the claim based on the fact it had a contractual obligation to pay out the sums, and did so. Mr. Wardell submitted gave rise to a good defence of change of position and or distinct defence of ministerial receipt. In my judgment, both defences are available, particularly emphasise the availability of the defence of ministerial receipt, received the payments in question, and became subject to an obligation to its customer to transfer them out of the accounts according to its instructions. Then at 246, the defence of good faith change of position recognised in Lipkin-Gorman is also available. And moving on quickly, the third question, if SEB was enriched in any relevant defence, is a defence of ministerial receipt change of position available to a claim under 145? And at volume 8 of the authorities bundle at 2683, the court concluded that a defence of change of position was in law available following the avoidance of a transaction under 127 of the Insolvency Act. And you'll find that at page 2683 of the bundle, tab 41, at paragraphs 39 to 40. There's a reference there, Mr. Nicholas Warren, to the Anderson case. My learned friend will no doubt take you to the Anderson case. And the judge distinguished the Canadian decision that there was no restitutionary, that defences weren't available to a preference claim on the basis that he was dealing with a different section, avoidance post-presentation of petition, and not avoidance of a transaction pre-petition. But there is no paragraph 40, he says there's two distinct conditions there. Further, no discussion of the relevant restitutionary principles, didn't refer to Lipkin-Gorman. Well, it's not clear why the judge thought that was a necessary distinction, because a payment from a policy perspective is exactly the same. A payment made prior to the liquidation is set aside if it's a preference, and the purpose is to increase the assets available for pari passu distribution. We've seen that from Lewis and Hyde. A payment made after the liquidation is set aside by statute, section 127. Again, the purpose is to restore assets available for pari passu distribution as at the date of the liquidation. They both have exactly the same statutory purpose. And the court has a discretion to validate a payment under 127, but the circumstances in which a court will do so, set out at rows, from my Lord's notes, I haven't got time to go to it, paragraphs 15 and 17, circumstances are such that the court would not exercise its discretion under 127 where the purpose of the payment was to prefer the creditor. In practice, therefore, there's actually no difference between the mandatory provisions of Section 145 and the discretionary provisions of, I say discretionary in inverted commas, because the section takes effect and mandatory, there is a discretion to reverse its effect. But that will not be reversed in the case of a preference. So there's no difference in policy terms between them. They both have exactly the same goal. And if restitutionary defences are available in one, they should be available in the other. The liquidator says there's a policy ground why the defence shouldn't be available. My learned friend will have to develop that in front of you. But if the court were to conclude that it was otherwise inequitable to require a creditor to restore payment to the company, what is it, one asks about Section 127, which would render the restoration equitable? Was the liquidator saying that the court will act inequitably? Public policy doesn't defeat a change of position defence. One can't just say public policy. We put in Charles Terence Estates. I haven't got time to take you to it, but it was a case where a local authority acted beyond its powers, its statutory powers. It acted for an improper purpose and in breach of fiduciary duty. The transaction was avoided, but there were restitutionary defences available. The fact that there is a public policy in councils acting lawfully can't be any greater than the public policy inherent in pari passu distributions. Indeed, if that's a public policy at all, as opposed to a private policy between and fairness between the individuals. Lipkin-Gorman, I won't take you to it, my lords will know it, and the passage, the powerful passage of Lord Gough at 579, 580, in the bundles it's at 2281. Would it be inequitable in all the circumstances to require SEB to repay the money to the liquidators? That's the test. So the fourth question, what are the relevant circumstances?
Well, perhaps it's worth emphasising that on your argument, there is a valid claim in unjust enrichment against the ultimate recipients.
Yes. That's right.
The only intermediary is an agent.
That's right, we're the intermediary. Agent, I was going to take you to authorities on agency, but we were on the register as the shareholder, albeit, as one of the points I'll come to, as nominee. So it wasn't. It was a trust relationship, a nominee relationship. Yes. We see no different why that should be any different from an agency relationship. Yeah. But there we are. So the fourth question, what are the relevant circumstances? Firstly, SEB acquired the shares as nominee and not on its own account. Secondly, SEB was obliged at all times to act in accordance with the instructions of its beneficiaries. Thirdly, SEB was obliged to account to its beneficiaries and had no right of recourse whatsoever against them.
Well, it had a right of indemnity, but I thought the evidence was that it was worthless.
Yes. It had a bit of paper, but it had no right consequent on that bit of paper. That was the evidence.
Well, it had a right, but it just wasn't worth powder and shot, as I understand it.
Yes, but not because that's because it was unenforceable. It couldn't be enforced. That was the evidence. Not that the indemnor was a man of straw.
Oh, why was it unenforceable?
Because under the Swedish financial services regime, as a matter of practice, the expert said, it simply couldn't be enforced. The bank would not be able to use it because of the impact that would have on the Swedish Financial Services Authority, which would take a very dim view of that. So he said it couldn't be done. I should say, my lord, my learned friends relied on this and said, your expert has given this evidence that you never had an indemnity worth powder and shot. Well, so be it. We never had it. Fourthly, the company knew that SEB was a nominee and noted that on its share register. Fifthly, SEB would not in any sense share in the risks or rewards of being a shareholder. And I've indicated to my lords, it's an unusual jurisdiction in that shareholders become creditors. Well, they're shareholders, they share in the risks and rewards, and then they flip into creditors. But SEB would never share in the risks and rewards. It wasn't taking a chance on the insolvency of the company so as to gain profit. And sixthly, SEB received the proceeds, credited them the accounts of the beneficiaries, and paid out lawfully and in good faith. And my learned friend relied...
Was it charging the beneficiaries for the service it was doing?
It was a commercial arrangement, my lord, yes. No doubt about that. The liquidators rely on the principle which I took you to in Lewis and Hyde, that the underlying purpose of Section 145 is to ensure compliance with the basic principle of insolvency law, viz. Pari passu distribution of the insolvent estate. As to that, firstly, the pari passu rule is a rule based in equity. It's the recognition that the assets of the company are, from the outset of the insolvency, regarded as being held on trust for the company's creditors. It's the basis of the pari passu rule. And equality being equity, the pari passu rule requires the assets are distributed ratably amongst the creditors. But as with any equitable rule, the pari passu rule will give way to a better equity. And an example of it giving way to a better equity is, for example, in cases of set-off in insolvency. In insolvency, when it comes to distributing the proceeds of what you've got in, you distribute it pari passu. Someone with the right of set-off can only set off if they've got a beneficial right to the debt. You can't set off a legal right against someone else's beneficial right. If SEB held for HQ Solid and Catella, it couldn't set off a claim for one against a claim against the other. So when it comes to the pari passu principle, it incorporates equitable defences, incorporates equity and equitable set-off. So there's no policy ground there for excluding equity when you're bringing assets in, if equity is had regard to when assets are going out. Further, so we say there's no policy reflected in the principle which requires SEB to pay anything from its own pocket when it never received anything into its own pocket. The pari passu rule is intended to promote equality between creditors. And what that must mean is that in the context of preference claim, the creditors are restored to the position that they would have been in at the date of the liquidation, but for the preference claim. You've got to repay the preference to put all the creditors in the position that they should be in as at the date of the liquidation, the commencement of the liquidation. But had the payments not been made, SEB wouldn't have paid anything to the funds. So had the payments not been made, the outcome of the liquidation would have been neutral for SEB, because on receipt of dividends, that money wouldn't have hit SEB's balance sheet. It would have gone straight to the funds. If the payments are recovered from SEB, SEB, alone amongst creditors, is worse off than it would have been if the payments had been made. So you're not restoring SEB to the position it was in prior to the payments. SEB is now in a worse position than it was in prior to the payments. And finally, my lords, I'd ask you to note again that SEB was overtly a creditor in trust for the funds. That's how it was entered on the register of members. So neither the company nor any other nor any other shareholder who became a creditor could claim that it was inequitable as between them and SEB to treat SEB as a bare nominee. That's how SEB came into the company. It was entirely overt. So,
quite a lot of nominee companies, aren't there?
Oh yes, my lord, and these defences will be of great interest to them as well, and had they been allowed to intervene, my lords would have been addressed by someone else on these points as well.
I thought you were saying your clients were in a unique position as nominee.
My lords, what I'm saying is that if this action succeeds, they alone of the creditors will have had to pay out. Other creditors may be able to run the same points. But, my lord, it goes back to exactly what I said right at the outset about the nature of the Cayman fund industry. One understands why Cayman hasn't developed its insolvency law in the way that other jurisdictions might have done, because these are not uncommon arrangements. This is how the Cayman fund industry works. They're not just one nominee, there may be layers of nominees. They're funds of funds. And certainty for this jurisdiction is important. And we say certainty is more important than recovery. Well, unless I can assist you further at this stage.
Thank you very much, Mr. Chivers. Mr. Shaw, do you follow? Mr. Lord.
First of all, a matter of housekeeping. There are only a few typos in our case. It's been corrected in the electronic version. There are paper versions available. Can I just tell you that there's only two that really matter. First of all, in paragraph 35, we attribute a quote to Lord Mance, but in fact, it's a quote of Mr. Justice Clifford having referred to Lord Mance. So the reference in paragraph 35 should be to Mr. Justice Clifford at paragraph 110 of his judgment. And the second one is in paragraph 55. The second line, there is an important word missing, which is not. So it should read,
Yes.
even if there was an element of trying to buy some time in Magnus Peterson's actions, that does not alter the fact. So, my Lord,
I've got a not in mine.
Yes.
We've got a not.
Oh, you do? Well, then I was being pessimistic then.
Yes.
Then it may well be that the written version's been corrected. Now, my Lords, by way of overview...
As mercifully has the electronic one, as you said.
Yes. My Lords, we say the Court of Appeal were right on all the issues for all the reasons they gave, as indeed was the trial judge, except for his finding on continuing intention. But as we will look in due course, in fact, that isn't all he relied upon, as I think Lord Wilson pointed out to my own friend while he was making his submissions. Now, my Lord, the second point is there's no appeal by my learned friend on any findings of fact. However, his appeals are on factual questions. So, as far as insolvency is concerned, he appeals the judge's findings that he was satisfied on the evidence before him that the company was unable to pay its debts. That's the issue that issues 1, 2 and 3 go to. Secondly, he appeals on whether or not the second and third redemption payments were made with a view to preferring SEB. Again, that is a factual question. Then he appeals on whether or not common law defences are available. I accept that's a pure legal question. But then he goes on to appeal the judge's factual findings in relation to it. And, my Lords, the other headline point is that in relation to these legal points, in our submission, SEB in effect have to invite you to depart from 3 of your previous decisions: Fairfield, Strategic Turnaround, and Primeo.
Finally.
The third one is a case we'll come to. It's Primeo against
Primeo,
Pearson.
right.
Yes. Now, my Lords, I propose to take issues in the same order that we've addressed them in our written submissions and Mr. Shivers did. As far as issues 1, 2 and 3 are concerned, they all go to the question whether or not Section 93 is satisfied, namely whether or not the judge was right to find that he was satisfied that the company was unable to pay its debts. Section 93 set out in paragraph 14 of our case, and my learned friend took you to the authorities bundle. Now, my Lords, the judge was clearly satisfied, and your Lordships can see that if I can invite you to turn to his judgment in volume 1 of the record, page 103. Appropriately enough, paragraph 93, he refers to section 93.
Although
and then
he adds, as they fell due to his understanding of what subsection C means.
Does. But nevertheless...
With a footnote. Oh, Ross, yes.
No, I don't think the footnote assists. And then paragraphs 94 on to paragraph 97, he goes through Mr. Stokoe's evidence, who was the previous liquidator. He then refers in paragraph 95 to a schedule that he asked us to produce. And, my lords, that schedule is in volume 3 of the record at page 1197. And what this schedule shows is it shows for the 4 months, October 08 to February 09, the monthly reported NAV, then the monthly swap value, and then the NAV less the interest rate swaps. And it also tells your lordship what percentage the swaps bore to the NAV overall. So you can see that by December 08, the value, once you stripped the swaps out, was a negative value of over 43 million.
Sorry, where do we get that?
December 08, third line.
Yeah, I got it.
Yes?
And is that because of the payments of the 19th of December, or partly because of those payments?
That's absolutely right. That's because of the December redemptions that the judge found, and indeed we say Article 34 makes clear, Article 36 makes clear, had become a liability as at the 1st of December. So, my lord, going back to the judge's judgment, paragraph 96, he points out that SEB had not pleaded any positive case that the company was unable to pay its debts, but simply did not admit that fact, and then refers to my learned friend's submissions, then refers to my submissions and references to the evidence of the directors, a whole host of emails that were before the judge, and other matters, before concluding in paragraph 98. He says it's clear on the evidence that throughout this period Magnus Peterson must have known there were insufficient funds to pay all the redemptions. And then 99, he says, taking account of all this evidence, including the unchallenged evidence of Mr. Stokoe, which I accept, I am satisfied that the joint official liquidators have discharged the burden of proving the company was unable to pay its debts. He then says, this is however subject to resolving 2 legal issues, which are issues 2 and 3, before your lordships. But my lords, that's by way of introduction, because that's why I say whether or not the judge was satisfied, because that's the test. He was, and he had lots of evidence before him. So, my lords, turning in particular now to issue 1, which we call the fraud point. We say, first of all, this is a very unattractive point for SEB to take. And that's a point made by the Court of Appeal in paragraph 20 of their judgment. In effect, what Mr. Shivers is saying is we should never have got our money back in the first place. But that is the very reason why you can't have it back now. That is, in effect, what my learned friend is saying. He's saying, we were paid out, we shouldn't have been, because the NAV was wrong. But having now been paid out, you can't now have the money back for the very reason that the NAV was wrong, and therefore the company, he says, wasn't actually insolvent.
I thought he was making a time bar point.
My lord, no, he makes a time bar point in the sense that he says that we've bought the wrong claim. He says you should have bought a claim for recovery of money paid under a mistake because the NAV was wrong, but you're now out of time for that.
Is it conceded that if you had to have recourse to a money paid under a mistake, you would be time barred? It is, okay.
Because, my Lord, we knew about the fraud in March. 5th of March is when the directors discovered it. Very quickly thereafter, they put the company into liquidation, and the liquidators were appointed, knowing from day one that the swaps were, in effect, worthless. I mean, there was a lot of investigation to be carried out, but from that moment on, knew. There's a suggestion in paragraph 63 of my learned friend's case that the liquidators are somehow seeking to take advantage of the fraud. That's simply not right. The company is the victim of the fraud. And all my clients want to do is to get back the money we say was wrongly paid out, so that they can then apply it in accordance with the statutory waterfall that applies in Cayman, so that all creditors, including SEB, are treated equally and in accordance with that statutory regime. My Lords, my last point by way of introduction is that the situation of a determined NAV being based on fraud is sadly not unusual. That's precisely the situation in DD Growth, indeed in Primeo, indeed in Fairfield. It's never been suggested in any of those cases that the NAV was not binding because of the fraud. Now, my Lords, the reason why we say it is binding is because of Article 34. Article 34 says it is binding, and that is designed to achieve the certainty that Lord Sumption talks about in Fairfield. And that's how the whole scheme of redemptions is designed to work. So that once a redemption request is submitted, it is irrevocable on the part of the shareholder. You see that from the offering memorandum, page 1361 of volume 3. And upon the redemption date, the shareholder ceases to be a shareholder and becomes a creditor.
Well, I can quite see why that should be irrevocable, but why does the subsequent conduct of a fraudulent NAV of itself undermine the shareholder's irrevocable decision to convert himself into a creditor, rather than merely give rise to an uncertainty as to for how much he's a creditor?
Well, I accept that, my Lord, but the whole purpose is that the fund needs to know who's in and who's out on a particular day. And so that is why it's irrevocable once a shareholder applies to redeem.
But I don't understand Mr. Chiver's case to be that these redemptions should be set aside.
No, it isn't.
It's simply that the NAV is invalid.
That is indeed his case. But the third proposition is at the heart of this, which is we say that once the NAV is determined, as Article 34 makes clear, it's binding.
We can read Article 34 as though any valuations made pursuant to these articles shall be binding on all persons. We could add, even if fraudulent.
Well, my Lord, even if it is subsequently ascertained that they were, to use my learned friend's phrase, tainted with fraud. Because that is precisely the situation that was the situation before the Privy Council in Fairfield. So in Fairfield, the determinations of the NAV were tainted. They were tainted by Mr. Madoff's fraud. And we say there's...
The distinction is that in that case, the valuations were arrived at in good faith, whereas in the present case, as Chivers argues, the board of directors was effectively Mr. Peterson, and he allowed these valuations to be issued knowing that they were fraudulent, and therefore the company was not in good faith.
My Lord, I understand. That is my learned friend's case. I'll come on to that in a minute and explain why he's wrong about that and why the valuations were carried out by the administrators as the articles and as the offering memorandum anticipates. And there's no suggestion whatsoever that the administrators were acting fraudulently or dishonestly or knew that they were doing anything else than correctly valuing the assets. And I'll come on to that, but can I first of all take your lordships to Fairfield? It's in bundle 6 of the authorities, behind tab 11. The articles are set out in paragraph 11, and my learned friend took them...
Sorry, page?
Page 2041.
Thank you.
And then 2042, my lord, is where you see the Article 11C, any certificate as to net asset value per share given in good faith shall be binding. And then
is it important that those words are inserted in the article in that case, given in good faith?
My submission, nothing turns on that. And then, if you can go forward to page 2044, you see the basic principles of restitution set out by Lord Sumption. And then the issue in paragraph 19, which is whether or not the effect of those terms is that the fund was obliged upon a redemption to pay the true NAV, ascertained in the light of information which subsequently became available, or the NAV per share determined by the fund directors. And then you get their lordship's decision in paragraphs 21, 22, 23 and 24. Can I invite your lordships at some stage to read those because they're terribly important. Just a few headline points. You see at the end of paragraph 21, Lord Sumption says it's unworkable on any other basis, having gone through the very similar provisions to the provisions we have. Paragraph 23, he says at the beginning that the alternative construction that was being advanced in that case on behalf of the liquidators was an impossible construction. And he explains why. If it were correct, an essential term of both the subscription for shares and their redemption, namely the price, would not be definitively ascertained at the time when the transaction took effect, nor at the time when the price fell to be paid. Indeed, it would not be definitively ascertained for an indefinite period after the transaction had ostensibly been completed. Because unless a certificate was issued, it would always be possible to vary the determination of the NAV per share. And he goes on to talk about the effect of that on members who either redeem or subscribe. Because you have people investing in and out of these funds all the time. But there is absolutely no certainty for them if there is always the risk that the NAV can be revisited at a later stage. So he concludes in paragraph 24, if as the articles clearly envisage, the subscription price and the redemption price are to be definitively ascertained at the time of the subscription or redemption, then the NAV per share on which those prices are based must be the one determined by the directors at the time, whether or not the determination was correctly carried out in accordance with the articles. So, my lords, we say that that decision of the board is the complete answer, as the trial judge found and as the Court of Appeal found. Because any other construction is impossible. it would leave members open or subject to an open-ended liability, and in effect would mean that any shares that were allotted, nobody would know for sure that they'd been allotted at the correct price, and it would always be possible at a later stage that everything would have to be revisited. And so I do urge you to read those paragraphs very carefully, but Lord Sumption goes through at some length explaining why he says anything else is impossible.
The matter would be capable of being opened up after the event if the NAV in any particular case had not been calculated in accordance with the articles.
Well, the problem you face is how many years do you have to go back over? You've got people on a monthly basis subscribing for shares and redeeming shares. And if you've got to revisit it all over a huge length of time, it becomes impossible. But it also becomes impossible for the investors because they don't know for sure. They may have invested in Weavering back in 2006, thinking it was a good investment. 2008, they get their money out. No doubt they've earned a substantial profit, a fictitious profit in one sense, but as far as they are concerned, a real profit. And perhaps they're holding it as nominees, as my learned friend's clients were, and that's paid out. Meanwhile, the client, the ultimate client, says, well, I'm now going to invest in a different fund. But if you've got to go back and revisit all of that, it's completely hopeless. The whole fund industry cannot work. That's not to say that there's no remedy, because there may be, and I put it no higher than that, but there may be, the Court of Appeal refer to the possibility of misrepresentation claims.
Sorry, possibility of?
Misrepresentation claims. So that somebody could say, I invested in a fund. It turned out that the NAV had been fraudulent. It's more likely to be somebody who's still in the fund who would say, well, when I subscribed for my shares, the price was inflated. Now this fund's worth nothing. I've got a misrep claim against you. I say nothing about they'd have to satisfy all the other requirements, but what I'm saying is there is not no answer to it. But as far as these funds are concerned, in this industry, that is why they all have articles which are very similar to the ones in Fairfield, to the ones before your lordships today. And the reason why they say the NAV, once determined, is binding, is in order to achieve that certainty. And your lordships will find that explained and the reasons given in paragraph 29, the first half of the Court of Appeal judgment. We don't need to go to it now, but that's where they deal with that. If I'm wrong about that, then we say this is not a case of what has been called internal fraud. It is not a case where Magnus Peterson fraudulently valued the NAV. The first point to make in this respect is, in this instance, as in a number of others, my learned friends have done a complete U-turn. The position they were adopting before the judge was that Magnus Peterson had no authority to do anything. And your lordships see that, and I'll just for your note, it's paragraph 69 to 74 of their skeleton argument before the judge, which is in the record volume 1, page 342. As we explain in paragraphs 24 to 25 of our case, Magnus Peterson did not calculate the NAV. PNC, the administrators, did. invite your lordships to take up volume 3 of the record. I just want to show you a couple of passages in the offering memorandum. At page 1344. 1344 is where the offering memorandum begins. 1351, you see first column, middle of the page, under the heading Administrator. The directors have appointed PNC Global as the administrator of the company. The administrator is responsible for the administration of the company, including the calculation and dissemination of the NAV. Now, just to contrast that, my lords, on page 1350, bottom of the first column, investment advisor, the manager has appointed Weavering Capital UK Limited to act as investment advisor, the investment advisor of the company. The investment advisor assists in the selection of investments and monitors the investment portfolio and performs necessary risk-return analysis. The investment advisor recommends to the manager any necessary alterations to the investment portfolio. Now, my lord, can I just pause there, because you will see above the definition of investment advisor, there is also a manager. What had happened, and you see this recorded in Mr. Justice Clifford's judgment, there was a proposal to insert a manager, a Cayman entity, as the manager between the company and the investment advisor, Magnus Peterson's company, WC UK. That apparently was proposed for tax reasons, but the evidence before the judge, accepted by the judge, was that it was never carried into effect. So that the way this fund worked is it had its board of directors, it then had WC UK, its investment advisor, carrying out the investments, and it had PNC, its administrator, carrying out the functions of an administrator. If you turn on in the offering memoranda to page 1357, in the first column, you'll see a reference to Magnus Peterson being the principal investment advisor to Weavering Capital UK. And then at the bottom of the first column, there's a heading, the administrator, registrar and transfer agent. And then in the second column, the second paragraph, the administrator has been appointed to administer the day-to-day operations and business of the fund, including processing subscriptions, redemptions, computing the net asset value and the net asset value per share, maintaining books and records, etc., etc. And then at 1364,
you've helpfully drawn our attention to that. I see that Mr. Peterson started his career with SAB. Is that mentioned in the evidence at all?
It was certainly something that everybody was aware of. But of course, Mr. Peterson didn't give evidence before the judge. But it's just part of the history, my lord.
Yes, thank you.
1364, net asset value. The articles provide for the valuation of the shares of the company by reference to the net asset value. The net asset value of the company and the NAV per share of the company is determined monthly, as at each valuation day, by the administrator and notified immediately to the Irish Stock Exchange. And then under the heading Determination of Net Asset Value, the net asset value of the company and the NAV per share is calculated in US dollars by the administrator as at close of business on the relevant valuation day. Net asset value per share will be available on request from the manager or the administrator within 26 days. And my lord, just while we are...
But while we're on that page, subparagraph E requires, I'm assuming that the swaps are within the definition of all other securities and assets.
Yes.
so that the company was required, the board was required to establish some procedures for determining what the value of the swaps was. It wasn't just a question of number crunching by the administrator.
Correct.
And there is something wrong. The net asset values were wrong because a completely wrong value was attached to the swaps. But the implication one gets from little e is that that process, far from being a matter of number crunching by the administrator, was something to be dealt with by the board.
I accept
And
that.
since the judge found that the board really delegated all its relevant activities, so far as this was concerned, to Mr. Peterson, why are we not to assume that Mr. Peterson, so far as anybody did, was the person responsible for saying what fair market value you should attribute to the swaps?
Well, first of all, my lord, one has to be very careful about my learned friend saying that Mr. Peterson was acting as a de facto director based upon what
I'm just
Mr.
thinking what the judge said.
Yes, but what he says is confined to decisions about redemption payments.
Yes, it's paragraph 57, isn't it, Mr.
That is what
We've
he
got
said.
that at 89.
Yeah.
And
Yes.
then I suppose we would look at paragraph 61. And did either the judge or the Court of Appeal consider your point? Oh, well, if it's relevant to look at whether it's internal or external, this is external.
No, because both of them were satisfied that
It didn't,
the article
it didn't
was
matter.
the answer and Fairfield was the answer. What my learned friend says is he says when you look at, and I can't remember the paragraph, the relevant paragraph of the Court of Appeal decision, he says that the Court of Appeal found it was a case of internal fraud. They didn't. They simply expressed no view on the matter. So what I'm addressing at the moment is if I'm wrong, if Mr. Justice Clifford was wrong, if the Court of Appeal was wrong, and Fairfield and Article 34 are not the answer, then whether or not the valuation was carried out by Mr. Peterson. And what I'm trying to establish, my lords, is it plainly wasn't.
Well, the judge found that the administrator's role was purely administrative
Yes, but I'm not...
at paragraph 60,
Yes.
which doesn't sound like a role which involves a value judgment about the fair market value of the swaps.
No, but again, my lord, what he's talking about is administrative in the process of the payment of redemptions. One has to be very careful, because if you look at paragraph 60, I specifically reject the submission of Mr. Shivers that PNC was part of the decision-making process in relation to the payment of redemptions. Because, as I explained to your lordship, my own friends have done a complete about turn. Their position before the judge was it wasn't Magnus Peterson. Now, the issue that we were concerned with was whose mind or whose intention was relevant when you were looking at section 145. And our submission was, it's Magnus Peterson, and their submission was, no, it isn't. And the judge found for us on that, but that's as far as his finding went in relation to when and where Magnus Peterson was acting as a de facto director. There's no other finding that he was generally acting as a de facto director. What he was doing was he was acting as a director of WC UK, which was carrying out the investments on behalf of the fund. And what PNC were doing was acting rightly as administrators, and they were carrying out all the functions that I've just shown your lordships described in the offering memorandum. What the judge is saying about their role being administrative in paragraph 60 is simply in relation to the payment of redemptions. Because, my lords, there was disquiet voiced by PNC at the time that these redemption payments were being made, and at the time that they were being asked to pay 25% to some of the December redeemers. And they were concerned because they were concerned about where the money was coming from. And really what the judge is getting at there is, yes, they were expressing concern, but at the end of the day, Magnus determined what was to happen, who was to be paid, when and where. And that was the issue that he was addressing. Well, the issue I'm addressing is a different issue, which is who carried out these valuations. Yeah. And in my submission, the answer to that is clear. It's never been in dispute. The valuations were carried out by the administrator.
Well, they were, I mean, all the documents speak of it being a process of calculation.
Yes.
In other words, applying policies laid down by the board, which, when you apply those policies to the books, produces certain figures. The key question is who placed a value on the swaps. And I assume the value placed on the swaps assumed that the counterparty was good for the money.
I'm sure that's right.
Effectively a face value in the market, out of the market.
Yes. So
market value of the swaps, rather than anything which took account of the swap counterparty's credit position. But was there any evidence about who did that?
There was no evidence about that. I mean, the reason why we are where we are is because of the complete volte-face that my learned friends have done. But the point is simply that these swaps, as my Lord Briggs has pointed out, were valued, no doubt, at their face value. They had a value, but it was worthless. And it was worthless, that value, because the counterparty was Weavering Capital Fund, the BVI company, that had nothing. They were real transactions. They actually were interest rate swaps. And therefore there was that sum of money due to the company, but it was never going to arrive. So the answer to my Lord's question is, no, it wasn't explored, but I suspect that there would be no doubt as to what actually happened. PNC were provided with the information about these swaps.
By?
By WC UK, because WC UK was carrying out the investments on behalf of the fund.
Would that be by Mr. Peterson?
Well, it's his
in terms
company.
of the individual who actually provided it?
Yeah, it may have been Mr. Peterson, it may have been somebody else.
Is that point dealt with in the judgment or in the evidence?
No.
Well, whether you're right or wrong about this, one might be forgiven for concluding that if there is a difference between internal and external fraud, it's a very porous one, and it might give rise to a lot of very difficult inquiries.
Of course.
Yes?
Which is why I come back to the point I've already dealt with and I don't want to come back to, which is Article 34 is clear, it is binding. But I mean, just to recap, Magnus Peterson or WC UK would have provided information about the investments to the administrator. The administrator would then have carried out its contractual obligations and calculated the NAV. Magnus Peterson had nothing to do with that. And there's no suggestion that PNC were acting fraudulently. And so we say practically there's no difference between PNC's valuation of the NAV and the valuation carried out by, I think it was Citco in Fairfield. But Citco, in that case, was relying upon information provided by Blimis, Bernard Lee Madoff Investment Securities, which was wrong in the same way as the information provided to PNC was wrong. But there's no material difference.
Well, except that Mr. Madoff was he de facto or controlling quasi-director of
Fairfield? No.
Of Fairfield?
No.
I mean, isn't that's the point that's
well, that's what my learned friend says, but that's why, my Lord, it's important to appreciate what the judge's finding was about Magnus Peterson's role as a de facto director. He was only a de facto director in relation to decisions about the payment of redemptions. That is not what we're considering at the moment. we're considering something different. We're considering the valuation of the NAV. And his role in valuing the NAV was the same, if you like, as Mr. Madoff's was in Fairfield. He was the perpetrator, in the same way that Mr. Madoff was, of the fraud that led to the NAV being wrongly determined. But he didn't value it. PNC did. I mean, as Mr. Falk reminds me, it's PNC's role that they have the interest rate swaps, they have the options and the futures that are also being traded, all by WC UK, and they have to value all of these investments. And that's what they did. And they did nothing different from what Citco, the administrators in Fairfield, did. And Mr. Peterson had no role at all in that, in the same way that Mr. Madoff didn't. But, my Lord, our third answer to this point, because if I'm wrong about both of the first 2 points, then we say that there's no question of attributing Mr. Peterson's knowledge to the company for these purposes. Lord, for that, we rely upon Hampshire Lands. That's in the Authorities Bundle 8, tab 33, page 2573 of the record.
I'm sorry, could you give me that again, please?
I can. It's volume
8.
Authorities Volume 8, page 2573.
Thank you.
Just looking at the head note, where one person is an officer of 2 companies. Now here we have Magnus Peterson as the actual director of WC UK and not a director, we say, of the company, the fund. His personal knowledge is not necessarily the knowledge of both companies. The knowledge which he has acquired as officer of one company will not be imputed to the other company unless he has some duty imposed on him to communicate his knowledge to the company sought to be affected. And then in the judgments, you can see page 2577 at the bottom of the page. The question, therefore, is this: is it right to impute this knowledge to the society? It is said that it is right because Mr. Wills was the common officer of both the society and the company and was aware of these irregularities. And I think it must be taken that he was aware of them. And then I think we can pick it up page 2579 towards the bottom of the page. Actually, just past halfway down. The case is very much more like the one which both Mr. Bramwell-Davis and Mr. Jenkins had to admit was an exception to the general rule that they sought to lay down. They admitted that if Wills had been guilty of a fraud, the personal knowledge of Wills of the fraud that he had committed upon the company would not have been knowledge of the society of the facts constituting that fraud, because common sense at once leads one to the conclusion that it would be impossible to infer that the duty either of giving or receiving notice will be fulfilled where the common agent is himself guilty of fraud. It seems to me that if you assume here that Mr. Wills was guilty of irregularity, a breach of duty in respect to these transactions, same inference is to be drawn as if he'd been guilty of fraud. I do not know, I'm sure, whether he was guilty of actual fraud, but whether his conduct amounted to fraud or to breach of duty, I decline to hold that his knowledge of his own fraud or his own breach of duty, under the circumstances, the knowledge of the company. Then, my lords, if we can just go to the decision of Getivia against Bilter, which is in Authorities Bundle 7, tab 17, and if your lordships could go to page 2164 of the bundle. This is in Lord Newburger's judgment. He says, paragraph 7, 5 lines down, where a company has been the victim of wrongdoing by its directors on which its directors had notice, the wrongdoing or knowledge of the directors cannot be attributed to the company's defence. The claim brought against the directors by the company's liquidator to denounce the company on behalf of the directors for the loss suffered by the company as a result of the wrongdoing, even where the directors were the only directors. And in paragraph 9, 6 lines from the bottom, he says, that paragraph, however, I agree with Lord Mance's analysis of paragraphs 37 to 44 of his judgment, that the question is simply an open one, whether or not it is appropriate to attribute an action by or state of mind of a company director or agent to the company on the company's principle in relation to a particular claim against the company on the principle must depend on the nature and factual context of the claim in question. And then, if you go forward in the judgment to page 2174, this is now in the judgment of Lord Mance. And he says, at the same time, however, if the officer's breach of duty has led to the company incurring loss in the form of payments to or liability towards third parties, the company must be able, as part of its cause of action against this officer, to rely on the fact that in that respect its officer's acts and state of mind were and are applicable to the company, causing it to make such payments or incur such liabilities. In other words, it can rely on attribution for one purpose, but disclaim attribution for another. And, my lords, we say that, in a sense, that is precisely this position. So that Magnus Peterson's knowledge is relevant and attributable to the company when he is deciding to make redemption payments. So when your lordships are considering whether or not the payments were made with a view and whether or not they were made with the dominant intention to prefer, it is Magnus Peterson's knowledge that is relevant. However, when your lordships are considering a completely different question, which is whether or not the company was able or unable to pay its debts, in that context, the suggestion by my learned friend, which is rather convoluted, which is that Magnus Peterson knew that the NAV was wrong, and therefore the company knew that, and therefore the company did not owe any obligation to any of the December redeemers, or the January redeemers, or the February redeemers, and knew all of that. Therefore, he says, the company wasn't insolvent. Because that's all this issue is directed to. Was the company insolvent? Were these debts, these redemption sums, were they debts of the company? And we say yes. But my learned friend seeks to say, no, they weren't. They weren't, and the company knew they weren't, because Magnus Peterson's knowledge is attributable to the company, and he knew that the valuations were false. But we say that is simply not a relevant inquiry. The inquiry is simply, was the NAV as determined binding? And we say, yes, Article 34 Fairfield. If I'm wrong about that, yes, because they were properly valued and determined by PNC, who was not involved in the fraud at all. But thirdly, if it does at all become relevant to consider Magnus Peterson's knowledge, you cannot possibly impute it to the company for these purposes, so that it can be said that the company knew that its NAV wasn't binding or was fraudulent. My lords, finally on this, as far as the winding up rules are concerned, we say they are completely irrelevant. The rule only applies in the case of a solvent winding up, and then is only relevant to the members. It can't be used to change the position between a company and its creditors. And it is concerned only with the situation where there is a pot of money to be returned to the members, and then it's necessary to look at what each should get. And in that scenario, the Cayman rules provide for the possibility of restating the NAV in order to achieve equity between the members. But that is only if you get all the way to the stage of a solvent winding up. It has nothing whatsoever to do with SEB, who had ceased to be a member and became a creditor. And it doesn't give rise to any of the concerns expressed by Lord Sumption, because it only arises during a liquidation once a liquidator has decided that there is money to distribute to the members. And then the rules provide for him to consider whether or not he should restate the NAV. That was what was being pursued by my learned friend in cross-examination of Mr. Stokoe. And my Lord Wilson's right, perhaps you may have to go back and have a look at the cross-examination because we say he hasn't quite put it fairly. But the reality is Mr. Stokoe said, yes, it is possible that we might have to, because at that stage, the fund had ongoing litigation against its auditors. So one can see that at that stage, Mr. Stokoe might have thought that there might be substantial recoveries to be made as a result of that litigation that would lead to that scenario. My Lord, we say that has got nothing to do with the question before your Lordship. So, my Lord, that's all I was going to say on issue 1. Issue 2, which is the 30-day point, that is only relevant to the first SEB redemption payment. And in order for my learned friends to make any traction in this regard, he has to succeed not only on the 30-day point, but also on the future debts point. The issue, as defined, asks when the redemption debts fell due. We say the answer is in Article 36. They fell due when they became a liability of the company. That was on the redemption day. That is the end of the question. My learned friend says, not quite right, because Article 55 provides that the company should remit the proceeds within such period as the directors shall determine, and the offering memorandum says redemption payments are generally made within 30 calendar days. And Lords, can I just ask you to have another look at that provision in the offering memorandum, volume 3 of the record, page 1361. Second column, middle of the page, redemption payments are generally made within 30 calendar days after the redemption day. No interest is paid from the redemption day to the payment day. Payment is made by telegraphic transfer, etc. Well, two small points on that. First of all, note the word generally. It's not even a definite date. So, what do SEB say? If the directors decided to extend that period by a further 30 days, do they say that the sums would not fall due for 60 days? And the second point is note the reference to no interest is paid from the redemption date to the payment date. Now, why is that provision necessary? Answer, because otherwise somebody would be claiming interest because everybody knew that the sum had fallen due on the redemption date.
So what is the proper analysis of the 30 days after the redemption date?
My Lord,
can the redeemer sue within that period?
Yes, he can. Can he present a petition to wind up? Yes, he can. What is the rationale for it? That is explained in footnote 22 to our case, which is that there needed to be, as a matter of practicality, a period of time for PNC to carry out its exercise once they knew how many shares were coming in, how many shares were going out, once they'd got the information to collate it all and work out what the figures were. Otherwise, the effect of this is that what my learned friend is saying is that when the first SEB redemption payment was made, and indeed the payments to the other 5 Swedish redeemers on the 19th of December, it was all paid early, and there was nothing due at that stage. Now, my lords...
Well, they didn't need time to work out who had to be paid how much, didn't they? Because the redemptions have to be served weeks in advance.
Yes.
The NAV is done, and the NAV per share, all on the redemption day, and it's simply a question in relation to each new creditor of comparing the number of that person's shares with the NAV per company.
Yes.
And that's just pressing a button on a not very sophisticated computer, isn't it?
Well, what the offering memorandum refers to is it refers, this is 1364, to the NAV per share being available generally within 26 days from the valuation day. So as I understand it, and I'll be corrected if I'm wrong, there was this period during which the administrators carried out their administration function.
So is the NAV not issued on the redemption day?
No.
Because they know they're going to have to issue a NAV every month anyway.
They do.
So why does that need... Oh, you say they need time because they need to be looking back at a fixed date?
They know the date they have to value it.
Yeah.
But as a matter of practicality, it took them 2 weeks or a little bit longer in order to carry out that valuation exercise. And I take my lord's point, it was only the question of doing a little bit of simple maths. But that is the way it worked with this fund, and indeed with other funds, because we'll see what Lord Mance said about it in relation to Primeo in a minute. My Lords, if we can now go to the decision of the board in strategic turnaround, that is in Authority Bundle 6, tab 10. My learned friend took your lordships to some of this. If we can look at page 2019. Article 53, similar provision to Article 36. The price to be paid for shares which are to be redeemed shall be deemed to be a liability of the company from the close of business on the redemption day until the price is paid. And then, as my learned friend took you to the other provisions of the articles, they're more or less the same, but in slightly different wordings to ours. As far as the CM is concerned, that's on page 11, page 2023. Payment of the redemption price will be made as soon as practicable, but except in cases otherwise described herein, as shareholders making a redemption will receive at least 90% no later than 30 days. Paragraph 15. The board turns, in the light of these provisions, to the issue whether the company had power to suspend the payment of redemptions. Page 2025, paragraph 19, bottom of the page, Article 53 provides that the price to be paid for shares which are to redeem shall be deemed to be a liability of the company from the close of business until the price is paid. And then paragraph 20, the focus of these provisions is on the redemption date, by reference to which the redemption price payable is crystallised, which the price is deemed to be a liability of the respondent. The remittance of redemption proceeds is treated as a matter of supplementary procedure, although it may be refused on, in particular, money laundering grounds. Then your lordship see paragraph 28, reference to the respondent's fluctuating position about when the redemption price was payable, and the conclusion one sees right at the end, paragraph 44.2, upon the court holding that on the proper construction of the Articles of Association and of the confidential explanatory memorandum, so far as relevant thereunder, the company had no relevant power after the 31st of March 2008 or at the date of the petition to suspend the payment. So what your Lordship sees, 31st of March 2008 is the redemption date. So the 30-day period referred to has no relevance to that. It is, as Lord Mance says in paragraph 20, treated as a matter of supplementary procedure and nothing more. And if your Lordships go back to paragraph 1 of the judgment, page 2013, Lord Mance says, paragraph 1, line 4, whether the petition was an abuse of process depends upon whether at the date of its issue the appellant was a current creditor withstanding to issue it, or at best a prospective creditor. And the answer he gives in 44.2 is not an abuse of process, because at the date of its issue the appellant was a current creditor and had become a current creditor, on the 31st of March 2008. Now, the only way in which the Court of Appeal differed from the Privy Council was not at all in relation to this 30-day period, but the Court of Appeal's view was that the company did have power to suspend redemptions, notwithstanding the fact that the redemption date had passed. That was the effect of the Court of Appeal decision. But all three courts were consistent in holding that the petitioner became a creditor, a current creditor, on the redemption date with an immediate right to present a petition. And that is what the Court of Appeal in our case say in paragraph 34.
I don't think we've seen that in Lord Mance's judgment, have we? I mean, his judgment seems to be saying that there was no power to suspend payment
Correct.
after the redemption date. But I don't think, the passages you've taken us to don't seem to focus on the particular point that we're concerned with.
Well, all they were concerned about was that the petition, having been issued on the 10th of June, was it or was it not an abuse of process? Yeah. And the focus was entirely on whether or not the suspension had been valid. But if you look, my Lord, as I showed you, paragraph 1, whether at the date of issue the appellant was a current creditor withstanding to issue or at best only a prospective creditor, and then you go right to the end of the judgment, paragraph 44.2, upon the court holding that on the proper construction of the Articles of Association, etc., the company had no relevant power, that's the power to suspend, after 31st of March 2008. Yeah. That is the date. That's the redemption date. It's not 30 days after the redemption date.
But it's not telling us at what point in time the payment became enforceable.
Well, not in terms, but...
Isn't it the difference between a future and a contingent debt?
Yeah.
You can, once the power to suspend has passed, it's a definite future debt. There's no contingency that it will fall due at a certain time, assuming the 30-day point against you for the moment. But in that case, the petition was issued long after the 30-day period had expired.
Yes.
And all that mattered was whether it had ceased to be contingent after the redemption date. But they're not there saying in terms, are they? A petition could have been issued before the 30 days had expired.
They're not, because they don't need to.
No, quite.
But what Lord Mance does say in paragraph 20 is he does talk about the other matters, the 30-day period being a matter of supplementary procedure.
Yes. I wonder what that means.
Well, let's go to Pearson and Primeo, which is in Authority Bundle 7, page 20, tab 23. In the bundle, it's 2407. The question in this case was when precisely does redemption occur? And you see in paragraph 2 on page 2407 the various interests that are represented. Herald, which advances the case that all investors who were unpaid as at the 12th of December 2008, that's the day after Bernie Madoff admitted his fraud, rank as ordinary members. Primeo represents investors who, under Herald's articles, either gave the necessary 35 days notice or had such notice period waived by Herald's directors and had their shares redeemed either on the 1st of December 2008 or at some earlier redemption date, but were not paid the redemption proceeds before Herald suspended further payments. Know your client redeemers don't really matter. They're just people who hadn't had money laundering checks carried out in relation to them. They had redeemed, but they also hadn't been paid. And then 3, Reichmuth and Co. appears by leave of the board as first intervener and represents the interests of the late redeemers, who prior to 5 p.m. on the 12th of December had given notice on a date to redeem after the company had gone into liquidation.
And the final class is those who hadn't even given notice on the relevant date.
That's absolutely right.
Yeah.
And then if we can go forward in the bundle, 2411, you see section 37, 7A, because this is why it matters of the company's law. Where a company's been wound up, and at the commencement of the winding up, any of its shares which are liable to redeemed have not been redeemed, and that was a question, or which the company has agreed to purchase have not been purchased, the terms of redemption or purchase may be enforced against the company, and where shares are redeemed or purchased under this subsection, they shall be treated as cancelled, provided that this paragraph shall not apply, and then you see the circumstances in which it's said not to apply. Now, as far as the articles are concerned, we see very similar articles to those in our case and in Fairfield. And if you can turn to page 2415, you see Article 18H2, participating non-voting shares to be redeemed under Article 20 shall be deemed to be outstanding until and including the valuation point, as at which the net asset value per share is determined, and after that time until paid the price thereof will be due to the company. 2419, in the offering memorandum, middle of the page, payment of redemption proceeds. Full payment shall be made, generally, within 20 business days of the relevant day. And then one sees paragraph 8, Lord Mance starts to summarise the argument advanced for Herald by Lord Goldsmith. And in effect, what Lord Goldsmith was saying is redemption is the whole process. It doesn't finish on the redemption day, but it continues as a process until payment is received. Paragraph 13, in the board's opinion, payment is, as a matter of general principle, clearly not an inherent element of the redemption or purchase by the company of its own shares. The provision in the articles for its deferral for a short time was no doubt a convenience to the company. The essence of redemption is, however, the surrender of the status of shareholder with all attendant rights, just as the essence of purchase is the transfer of property. If this occurs, the deferral of payment of the price is no more than a grant of a short period of credit to the company without any reservation of property or interest. So Lord Mann's echoing what he had said, paragraph 20 of strategic turnaround. The grace period, which is what my learned friend's been calling it, actually does not affect the liability, doesn't affect when the payment is due. It's simply a matter of convenience for the company, in the same way as the 30 days was a matter of convenience for the company in our case. Paragraph 16 is the reference to strategic turnaround. My Lords, at some stage I'd invite you to read that. And then paragraph 20, the board notes, finally in this connection, Lord Goldsmith's submission that Primeo's case means that the December and the KYC redeemers can prove in Herald's winding up on the basis of inflated valuations based by Herald on a belief in the genuineness of Plymouth and in its transactions, whereas Plymouth was in reality a Ponzi scheme of far less worth than appeared. In his submission, Primeo's case conflicts with the principle that the tree must lie as it falls. The board has considered this. Reference to Fairfield. Paragraph 21. Fairfield involved an attempt to recover redemption monies which had already been paid. The present issue did not arise, and it was not necessary to draw the precise line between those investors whose funds are still invested and those who were still members of the fund at the critical date, which is here the commencement of the winding up. That line now falls to be drawn, and the board's conclusion is that the critical moment is when an investor has redeemed and so ceased to be a member of the fund, becoming, instead of creditor, owed the redemption proceeds. On this basis, the fact that the debt constituted by the redemption proceeds is provable together with, being subordinated by Section 94G2 to other debts owed by Herald Congress, no basis has been suggested on which Herald could, on this analysis, disturb the valuation by reference to which such redemption proceeds were calculated. My Lords, you find the conclusion in paragraph 22. So, my Lords, we say that that is entirely consistent with strategic turnaround, makes it clear that the grace period, as appears in the offering memorandum of all of these funds, albeit a different period, is a matter of convenience only, does not affect the question of liability, that is governed in all of them by the articles, and does not affect the question of when the payment falls due. My Lords, the Court of Appeal dealt with that in paragraph 40 of their judgment, and in effect considered that the matter was decided by strategic turnaround and reached a similar conclusion. My Lord, then finally on solvency issue 3, the future debts point. SEB's argument seeks to confine the cash flow test in section 93 to debts that have actually fallen due, and to include any consideration of debts that it is known will fall due in the reasonably near future. I should make it clear, my submissions now are on the assumption I'm wrong about the 30-day point. But, my Lords, that is not what the section says. It simply refers to the company being unable to pay its debts. The word debts is general and suggests the sort of wide, flexible and fact-sensitive test desirable in dealing with a concept that has to deal with a huge range of circumstances that potentially could arise in an insolvency. And in our case, the company was obviously insolvent once the swaps are known to be fraudulent. And indeed, that's why the directors immediately put it into liquidation.
Well, why? On the face of things, if the NAVs are not binding because they're fraudulent, then if you calculated proper NAVs, there would only be a fraction of the ones that were in fact calculated, and the members who redeemed would receive what they were entitled to, and it's not obvious that there would be any insolvency.
But the redemption date, the company went into insolvent liquidation in March. By that stage, the debts of the December redeemers, the January...
Yes, it was rendered insolvent by paying out on the basis of fraudulent NAVs.
Or not paying out because it didn't have the money, but actually the redemption dates passing, those redemption debts being liabilities of the company, meant it was hopelessly insolvent. But what I'm addressing at the moment is simply whether or not future debts are to be taken into consideration by the court, because it's the court that has to be satisfied that the company is unable to pay its debts for the purposes of Section 93(1)(c). And just in Mr. Justice Clifford's judgment, paragraph 112, on page 112 as well, of volume 1 of the record, he makes the point is made that the analysis must be wrong. This is the analysis that is only current debts currently due, because it could lead to absurd results. For example, if a company owes a main contractor a substantial sum of money that it has no prospect of meeting, but that contractor agrees not to enforce it for a period, i.e. grants a 7-day period of grace for payment, and during that period, the company pays off its bank overdraft in order to relieve its directors of any obligation pursuant to personal guarantee or payment liquidation. In SEB's argument, that payment could not be a preference within Section 145. But he's dealing with the question of preference. If you're dealing with the question of unable to pay its debts, if a company knows that tomorrow a huge sum is going to fall due to one of its creditors, in my submission, it is absurd to assume that you do not take that sum into account in working out on the day before it has to be paid whether or not a court can be satisfied that that company is unable to pay its debts. My learned friend relies upon the old case of European Life Assurance, and I don't want to take your lordships back to that, but instead to go back to a case he did take you to, which is Eurocell, which is in bundle 6 of the authorities, behind tab 3. Page 1811. My learned friend took you to this. It concerned the question of events of default under loan notes. The events of default in the loan note are set out in paragraph 5 of the judgment, page 1816. And it's been unable to pay its debts as and when they fall due. That's the same as section 1231E of the Insolvency Act and has the additional words as they fall due, which is not in the Cayman provision. And indeed, paragraph 26 of the judgment, 1822, the words as they fall due did not appear in the legislation here until 1985. My learned friend took you to paragraph 28, where Lord Walker is not particularly flattering about the European Life Assurance Company case. He refers below, between C and D, to the extemporary judgment with very little reasoning. And then just above G, he says it's unfortunate it's come to be regarded as a leading case. And then paragraph 35, page 1826, he says there's no doubt that as a matter of form, the statutory test for a company being unable to pay its debts is materially different from the position under the Companies Act. 123 introduce the words as they fall due. He then goes through some of the background to that, and then paragraph 37, he says, despite the difference of form, The provisions of section 1231 and 2 should, in my view, be seen as the government spokesman in the House of Lords indicated, as making little significant change in the law. That is the addition of the words "as they fall due." The changes in form serve, in my view, to underline that the cash flow test is concerned not simply with the petitioner's own presently due debt, not only with other presently due debt owed by the company, but also with debts falling due from time to time in the reasonably near future.
I'm very sorry, Mr. Lord. Which paragraph are you in?
Paragraph 37, my lord.
Thank you.
And I've just read the first 7 lines of that. What is reasonably near for this purpose will depend on all the circumstances, but especially on the nature of the company's business. So, my lords, in my submission, the Supreme Court have made it clear that as they fall due in England, those additional words, has not made a significant change and merely served to underline that inability to pay debts includes debts falling due from time to time or in the reasonably near future.
Isn't that contrasting the position after the change in the law with the previous law, which would include the 1907 amendments?
My lord, as I read that, what he's talking about is the addition of the words "as they fall due."
Yes, but the Act already required contingent and future debts to be taken into account, didn't it?
My lord, I'm not sure I quite follow.
Well, we went through this with Mr. Chivers, that the 1862 Act provision was interpreted in the insurance company case, European Life Assurance, and then the law was changed in relation, initially life assurance companies, and then more generally by the 1907 Act, to enable a wider view to be taken.
It's all in paragraph 29 of this judgment.
And so it's that position that's being contrasted with the position after the insertion of words "as they fall due."
Yes.
What's not being... We're not contrasting the effect of adding "as they fall due" to the 1862 Act, which would be the equivalent exercise for Cayman.
My lord, I accept that. Not quite. No, they're not. But in my submission, the comments apply equally because, my lord, I'll go back overnight and reread it and perhaps deal with this, if I need to, briefly first thing in the morning. But my lord, in my submission, a test that interprets "as they fall due" as including debts falling due from time to time in the reasonably near future makes perfectly good common sense, and does so particularly in the context of a fund which knows it has a large number of redemptions to meet on a certain date. It's different from a normal sort of business. A fund knows what is going to happen in the future because of the requirement to give more than a month's notice in order to redeem. And in my submission, in those circumstances, it makes perfectly good sense for the test in section 91C, whether or not a company is unable to pay its debts and that being judged by the court, to be a broad test whereby the court says, well, yes, when we look at it, is this fund able to pay its debts? We're not going to look at it only in relation to those redemptions that have already fallen due, because we know all about next month's redemptions as well, as indeed does the company. And in my submission, it would be very strange if you simply took those out of the equation and said, well, no, in actual fact, this company was perfectly solvent on the 30th of December, if my learned friend's right about the 30-day grace period, because it didn't owe any sums on the 30th of December, despite the fact it owed 90-something million of December redemptions, whose redemption date was the 1st of December, whose article said that they became a liability of the company on that date. But nevertheless, you could ignore all of that, and the directors would have been quite entitled to say, no, we're not insolvent yet, albeit we know we will be tomorrow.
But strictly speaking, the question is not under the Cayman statute, is it? Whether the directors would be well advised to put the company into liquidation.
No.
It's strictly whether a creditor has locus to apply for a winding up order by the court on the Section 92 D ground, namely that the company is unable to pay its debts, because Section 145, which again doesn't govern when directors ought to be putting the company into liquidation, is all about preference, but it is insolvent within the meaning of Section 93,
Yes.
which then contains provisions which might not look quite so silly if it simply constrains the number of people who can present a winding up petition, and wouldn't constrain them under the European life case from, for example, presenting a just and equitable petition in the same circumstance.
I follow all of that. So that's how you get, my lord, to the test. But the test is still whether or not it's proved to the satisfaction of the court that the company is unable to pay its debts. And that's why at the very beginning I pointed out to your lordships that that is a factual question. That is a factual question that was answered by the judge in paragraphs 94 to 99 of his judgment. He had the evidence of Mr. Stokoe unchallenged. He had the evidence of the directors. He asked for that schedule that I showed your lordships as well, and he reached the conclusion that he was satisfied. And in my submission, that is plainly right. This company was unable to pay its debts. What my learned friend seeks to do is, in my submission, a completely false analysis, which is to say, well, it's not quite right, because when the first SEB redemption payment was made on the 19th of December, despite the fact that there'd been 90 million worth of redemptions and that they had become a liability of the company on the 1st of December, there was a grace period. And then when you put yourself in the position of somebody on the 19th of December, there were no debts that Mr. Lord or the liquidators have been able to identify that were actually due on that date, albeit there were a whole load of debts that were going to fall due 2 weeks later. And, my lord, this is insolvency. And one has to approach it with a degree of common sense, which is why the section says, to the satisfaction of the court.
Mr. Lord, am I recollecting correctly that it's common case that the cash flow test applies in the Cayman law?
It is. It is the cash flow test.
So you're saying Lord Walker's is the recent and perhaps binding
I do.
interpretation of that?
Yes.
Yes.
And I say it includes future debts, as in all debts that are due in the reasonably near future. Lord, it's probably not sensible to move on to the view now.
Very well. Thank you very much. We'll resume tomorrow. Court is adjourned.